Ms. Portillo, did you review the document entitled Motion to Enter Adjudication of Guilt with your attorney? Did you understand it?
Yes.
Welcome to my channel, Gavel in Silence.
All right. Court is going to call 2023 CR 8725 and 2023 CR 8727, State of Texas versus Terrence Bowie Jr. Could I have parties announced for the record for the state? Defense?
Scott McCrum for Mr. Bowie.
All right. Are you Mr. Bowie?
Yes, ma'am.
Counsel, have you received all the discovery in each of these cause numbers, and did you review it with your client?
Yes, I have, and I did.
And each cause number, the court will find that the state is in compliance with discovery. And each cause number, Mr. Bowie, did you review the documents entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
And each cause number, did you review what's entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, in each cause number, do you waive the reading of the indictment?
Yes, Your Honor.
State, in each cause number, are you proceeding on the indictment as presented? Okay. And the cause number ending in 8727, it appears that you're proceeding on the lesser included offense of possession of a controlled substance, penalty group 1 gram to 4 grams. Is that correct?
That is correct, Your Honor.
And in the cause number ending in 25, it appears that you're proceeding on count 2. Is that correct?
Yes, Your Honor.
Yes.
All right. And counsel, the court knows that you're not the party who put the plea paperwork together.
They didn't follow my guidance on writing it down, so
All right.
that will be talked about.
All right, Mr. Bowie. I'm sorry, counsel, do you have any objections to the state proceeding on the lesser included offense and waiving counts in each of the indictments?
No objection.
All right. Mr. Bowie, did you review the documents entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions in each of the cause numbers?
Yes.
With your attorney, did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
And the cause number ending in 27, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1 gram to 4 grams. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. And the cause number ending in 25, the state is proceeding on the possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a 2nd-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement in each of these cause numbers, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand in each cause number you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each cause number?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your probation were revoked, the court could find you guilty? And in the cause number ending in 25, the court could sentence you up to 20 years in prison. And the cause number ending in 27, the court could sentence you up to 10 years in prison. And in each cause number, the court could sentence you up to a $10,000 fine as well. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense in each cause number?
Yes, I do.
Mr. Bowie, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial, silent on your applications. The cases will run concurrent and they'll take in consideration 2023 CR 8726. All right, the court is calling 2016 CR 0791 State of Texas versus Wesley Darnell Mulkey. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
David Andre Woodard for Mr. Mulkey.
Are you Mr. Mulkey?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Wesley Darnell Mulkey who was placed on community supervision in 2016 CR 0791 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on October 17th, 2016 for a term of 5 years and extended for a total of 3 years?
Yes, ma'am.
State?
Yes, Your Honor. Violated condition number 1 on or about the 17th day of March 2024. In Bear County, Texas, the defendant, Wesley Darnell Mulkey, committed the offense of driving while license invalid in violation of condition number 1.
How do you put to that, true or not true?
We'll waive the remaining violated conditions.
Any objections to the waiver?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, court could find it true, grant the motion, find you guilty, and sentence you up to 8 years in prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court is going to find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It's to grant the motion to the revoke and sentence him to 2 years in TDC, Your Honor.
All right.
That's our agreement, Judge. We're just asking the court to follow it.
All right. The court is going to find you guilty. The court is going to sentence you to 3 years in the prison. The court will give you credit for any time served, and the court is going to ask for the therapeutic community. Are there any other credit he would receive?
He wouldn't, Judge, but I believe the agreement was for 2 years. I know the court does not have to follow the agreement. But we would just ask the court to follow the recommendation of 2 years if possible. But there's no other time he would be getting.
Judge, he did successfully complete SATIF. There was 2 time frames, one for 119 days and one for 42 days.
All right. The court will give him credit for any inpatient treatment that was successfully completed. All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Because this was not a plea bargain agreement, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion. All right, we can go off the record. Mr. Mulkey,
Yes, ma'am.
I see that this motion to revoke wasn't signed by the court. It was signed by Judge Glenn, which means that you were in felony drug court.
Yes, ma'am.
You're going to have to do better. Otherwise, the last time you use may be the last time you use. You understand?
Yes, ma'am.
All right, good luck to you, okay? Joshua, tell us,
Yes, Your Honor.
but y'all are on this side.
Yes.
And where's your client? Come forward.
Yourself to the judge.
Your Honor, I'm gonna go as far as
Okay.
with Cutter and Associates.
So are you in law school or where are you attending law school?
St. Mary's.
Oh, wow. What year?
I'm a 2L now.
2L? Oh, well, you're practically done.
Yeah, I'll be almost.
Well, please, whenever you want to come down, you're more than welcome to come down to the court.
Thank you.
You're welcome. All right. Who is the prosecutor on, how do you pronounce your last name?
It's Thayes. It's like TH. It's pronounced THE.
Tayez.
Yeah.
All right. So if you all will move towards this way, because counsel, you're on this side and your client is in the center.
How you
The
doing?
double
today,
L's,
boy?
I'm doing great. The double L's always get me.
Yeah, the E has that little apostrophe on top of it. So yeah.
Well, we're going to blame it on that because in the documents, they don't have apostrophe over the E.
Yeah.
So Tayez. Do you all have the motion?
We have the motion as well as the agreed order, Your Honor.
All right. So if you could give me the motion. Thank you. All right. Court is calling.
Now pay close attention. This is where the stakes get real. The defendant is pleading on a lesser included offense that's a legal strategy to reduce potential punishment. But make no mistake, the range here is still serious. 2 to 10 years in prison. How would you feel if your fate hung in the balance like this?
2020 CR 2266B, State of Texas versus Joshua Tayez. That party is announced for the record for the state.
Jason Garrett, Your Honor.
Defense.
Your Honor, Anthony Bancroft standing in for Miss Lee Cutter.
All right. And then you have with you also.
And I have my.
You want to announce?
I go as far as
All right. Thank you. And are you Mr. Tayez?
I am.
All right, Mr. Tez, you have an attorney who's standing in for Attorney Cutter. Do you have any objection to to this attorney standing in for Ms. Cutter for this hearing?
No, ma'am.
All right, so we're here to set a bond. He's on deferred adjudication, so he's entitled to a bond. It's my understanding that the state and defense have reached an agreement of $10,000. Is that correct?
That is correct, Your Honor.
That's correct, Your Honor.
All right. For the record, the court is aware of the defendant's history because he is on deferred adjudication out of this court. And the court has done the appropriate research that's needed in order to set a bond. The court will find that the bond in the amount of $10,000 that has been agreed upon by the state and the defense is an appropriate bond. Now let's talk about conditions. Based upon your history, the court is going to order that you do weekly UAs with probation until your case is heard. Do you understand?
Yes, ma'am.
And we're going to set this. Normally, we need a hearing. Just set it for a contested hearing. I don't know if it's going to be contested or not, but we'll put it on a contested date. And we're off the record. All right, we're coming back on July 11th at 9 a.m. And that will be your hearing. I am telling you this. I always keep an open mind on everything. But between now and then, if there's some issues in the motion to revoke that need to be addressed with you doing certain things, it would probably be in your best interest to do those things. And when I put on here that you're to do weekly UAs from now until then, you had better do weekly UAs from now until then. You understand?
Is there a designated day or do I just go on?
Oh, probation is going to let you know. So they're going to keep you out here till you talk to probation. And Ms. Ferguson, if you can give them a reset form.
I'm doing. I just need the file, Judge.
All right. Here you are. All right. That will be it.
All right, then, Ms. Boyd, you have a good day.
All right. Thank you. You too. All right. Court is calling 2023 CR 2172 State of Texas versus Satara Portillo. Could I have the parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
The attorney of record is Joanna Hoyos. Joseph Statesman standing in. Ms. Portillo, will you give this court permission for me to do this in place of Ms. De Hoyos?
Yes. All right. Ms. Portillo, did you review the document entitled Motion to Enter Adjudication of Guilt with your attorney? Did you understand it?
Yes.
Are you the same Satari B. Portillo who was placed on deferred adjudication in 2023 CR 2172 for the offense of possession with intent to deliver a controlled substance penalty group 1, 4 grams to 200 grams on July 27, 2023 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violating condition number 35 on or about the 25th day of March 2024 in Bexar County, Texas. The defendant, Satara B. Portillo, who then and there failed to follow the TAP recommendations to include inpatient as directed by the court in violation of condition number 35.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objections to the state's waivers?
None.
Did you understand by pleading true to violation of condition 35, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 35? Court will find violation of condition number 35 true. Is there a proposed agreement?
Yes, Your Honor. It's to alter demand for state ISF, the substance abuse program, followed by aftercare with ISP, weekly UAs with zero tolerance.
All right, so what I can tell you all, if you want to reconsider things, you can, but I'm not following that agreement. Anthony Cochran, come forward.
Good morning, Judge.
Good morning.
I do like the yellow.
Oh, you know, it's my mom had a yellow rose of Texas and it grew so high, it grew to the rooftop. Yes. And then my mom had someone moved it,
And it didn't make it.
didn't make it.
We had one at my parents' old house. We didn't try to move.
Yeah. But the roses were
Uh-huh.
huge.
You just get, when it gets that big, they get.
Yes. Now they say with roses, they've started, I don't know what the other term for it other than breeding. Well, they've been cross
Mhm.
referencing it. So they're trying to take the scent out because it attracts the bees and everything. I guess people want that. But if you look at roses now and sniff some of them, usually it's only the antique roses. They'll still have
Mhm.
their strong fragrance, but a majority of them don't.
So
And I'm just, yeah, it is. It's like, guess what? let the bees find where they need to go.
We need bees too.
Yes.
Normal bees is a bad thing.
Yeah.
Judge, I represent Mr. Cochran on two cases. They're both massive. I've looked, there's over 40 videos on one and over 35 on the other. I'm through looking at about half of it right now, so I don't really want to sign a discovery acknowledgement just yet because I'm not sure if there's other stuff that I need to request.
All
from
right, who
the
you
state.
conferring with?
I've conferred with Jason this morning. I can't advise my client to take or not take a deal.
No,
yet,
no, no,
so-
I'm just trying to
Yeah.
figure out if an offer was tendered.
No, I didn't ask for one, to be
Okay.
fair, but we did talk and I explained to him, we've been going through watching the videos at the office,
All
so.
right, so I'm going to give you all a 30-day reset. This
That's
is going to be the last time.
Okay,
And then at the 30-day mark, the state will need to tender an offer. Then what will end up happening is your next date after that will be a plea deadline date.
Yes, ma'am.
I'll explain all that to him.
All right,
Thank you so much,
Thank you.
Judge.
What date, Ms. Ferguson? 30 days? Yes. All right, July 16th. All right, July 16th.
Okay, and that day I'll sign the acknowledgement. and we'll get
All right.
moving.
Your Honor.
You're welcome. Once you sign the reset form, you're excused. Where are we on discovery?
Judge, this is the first setting. We do have a lot. I'm trying to make sure I have all of the body cam footage for every single officer. It's a lot to go through, so I'm still working on it.
Here is a critical moment. The court is explaining the defendant's rights. By entering this plea, he's giving up his right to a jury trial, to confront witnesses, and to remain silent. It's the kind of choice that could change a life forever. Would you make the same decision?
I have a lot, so I may have it all, but at this point, I'm not confident and able to tell you that I'm not missing things.
All right.
I did file a motion to suppress on this case. I'd like to have a hearing before trial if possible.
Motion to suppress what?
Statements.
All right. Of your client?
Yes, Judge.
Okay. All right, Ms. Ferguson. On this case, recall it for discovery. Mr. Camarillo, we're going to recall this for discovery in 60 days to give your attorney time to make sure she has everything. And state you believe you've uploaded everything?
I just checked the case out on Thursday or Friday of last week. I believe most of the videos are there, but again, that's not to say that maybe one's missing or something. And if it comes to light, we can definitely obtain it.
All right. If you're, Norma, 60-day reset.
60 days runs on a Friday, Judge, so I'm gonna shoot it for August 19th. It'll be a Monday.
All right. We'll be back on August 19th.
August 19th.
Do you have any questions?
No, no.
All right, so we'll bring you back on August 19th. What's going to happen on August 19th is just a date to make sure that your attorney has everything about your case. You understand?
Yeah.
All right, thank you.
Thank you, Judge.
You're welcome.
Go have a seat.
Notice how the court methodically confirms competency and voluntariness every. Yes, ma'am is crucial. It's the courtroom making sure there's no duress, no coercion. This is where legal safeguards actually matter. Watch closely the sentencing. Here is nuance. The judge mentions a recommended 2-year term, but also makes it clear she's not bound by it. That tension between plea agreements and judicial discretion is what keeps courtroom drama so intense. And now we shift gears. Probation, weekly drug tests, and a contested hearing looming. This isn't just paperwork, it's a test of compliance. And discipline. One misstep could trigger serious consequences. The pressure is real. Here is a jaw-dropping detail. The court could sentence up to life for a violation of conditions. That's the kind of reality that makes deferred adjudication high stakes. Notice how the proposed alternative focuses on rehabilitation, not just punishment. What would you choose if it were your future on the line?